This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about a person who committed a hit and run and then filed a false accident report only to find herself punished for insurance fraud, among other crimes. Where there were two different acts of insurance fraud, she claimed she could only be sentenced for one rather than twice for the same crime, and ignored the fact that it's just not nice to lie to your insurance company. Melissa Brewer appealed the judgment entered after a jury convicted her of leaving the scene of an accident, 2 counts of presenting a false and fraudulent insurance claim, 2 counts of preparing a false or fraudulent insurance claim, and misdemeanor reckless driving. In the People v. Melissa Brewer, the California Court of Appeals on October 14, 2024, dealt with her sentence to 4 years, 8 months in state prison, consisting of a consecutive term of 8 months as to count 1, 3 years as to count 2, and a consecutive term of 1 year as to count 4. She was also sentenced to 180 days in county jail as to count 6. Brewer's sole contention on appeal is that the trial court should have stayed imposition of the sentence as to count 4, an extra year in prison. Brewer recklessly drove her vehicle southbound on the 101 freeway in the area of Avila Ridge before she collided with a motorcycle operated by James Hayes. Several witnesses called 911 and stopped to render aid. Appellant did not stop. Hayes suffered an open fracture dislocation of his left ankle and multiple abrasions. However, he died before trial. After the collision, Brewer filed an electronic claim with her insurance company for damages to her car. In her claim, Brewer did not report her accident with the motorcycle, but claimed that her vehicle went off the road, went into a ditch, or rolled over. She also indicated that there were no passengers and no injuries. Brewer later sent an electronic communication to her insurance company stating, quote, "I'm having some stiffness in my upper body and neck, and I went to the chiropractor on Friday, April 2nd, and it's still pretty uncomfortable. I just wanted to notify you that I'm going to be making another appointment on Monday, April the 5th, and I will keep you updated on the outcome," close quote. This false statement was the basis of the 4th count, a different kind of insurance fraud. Brewer contended that the trial court should have stayed the sentences to count 4 because the insurance fraud convictions connected with her conduct were part of the same course of conduct as the insurance fraud convictions connected with the hit-and-run conduct. Substantial evidence supported the trial court's implied finding that appellant harbored separate interests and objectives in her commission of counts 2 and 4. After presenting numerous witnesses and evidence at trial, the prosecutor argued appellant's intent in filing the claim was to fix the damage to her car as quickly as possible to get rid of any evidence of her involvement in the hit-and-run collision. On the other hand, appellant's intent in sending the injury communication was to seek reimbursement for her medical treatment, a completely different thing than the damage to her vehicle. Her intent in sending the injury communication was to seek reimbursement for her medical treatment, and she therefore committed 2 separate acts of insurance fraud. The trial court therefore could reasonably have concluded, based on the evidence, that Brewer's offenses were separate and distinct and did not arise from a single indivisible course of conduct Her contention that she should not be punished twice for the same loss or injury was found to be totally meritless, and the judgment was affirmed. In my opinion, Mrs. Brewer's attempt to avoid a concurrent 1-year sentence was contumacious. She added to the horrible act of striking and injuring a motorcycle rider, failing to stop and running from the scene with a claim for the damage to her car, with a false statement as to how it was damaged, and then to claim bodily injuries from the accident, was just nasty. The court did not fall for her claim, and she will spend her full sentence in the Gray Bar Hotel. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog and you'll receive notice of every blog posting, usually 5, sometimes 6 a week, and you will have access to the more than 4,900 blog postings. You can also subscribe to these videos on YouTube and rumble.com, and if you do, I'd appreciate it if you click on the like button on YouTube and the thumbs up button on rumble.com. Please tell your friends and colleagues about the blog and these videos, and let them also subscribe. If you're interested in further detail about insurance, insurance claims, insurance fraud, and insurance law, please consider, for a very small fee, subscribing to my Substack publication. Thank you for your attention.